July 17, 2014. We all had an opportunity to review those now.
Yes.
Any changes, additions, deletions? Well,
No.
okay, I have some changes here, and if you go to the third page, please, you will see that on top there, it talks about issue number 2, and that's correct. Issue number 3. Stewart moved, Bucho seconded, that the Planning and Zoning Commission's finding that MEA's mitigation measures were insufficient was not supported in the record by substantial evidence. And that motion passed, as stated there, okay? Following that, however, we need to insert something, and that is that the next motion that was made was a motion made by John Hexby and seconded by Robert Stewart to substitute the board's independent judgment that MEA's mitigation measures were sufficiently supported in the record. That was the motion, and that needs to be added following the issue number 3, the initial vote there, okay? Then it needs to say, with the consent of all present, the motion was amended to read. And then we have what's listed there, to substitute the board's judgment as follows: MEA's mitigation measures were sufficiently supported in the record with respect to specific mitigation measures of lighting, noise, drainage, and landscaping, adequately buffering surrounding residential uses. Okay? And underneath it needs to say, where it says, and the motion the motion as amended passed with a vote of 2 to 1. Ayes, John Hexby and Robert Stewart. Nay, Ernst Bucho.
I agree.
Does that make sense? That accurately reflect what we did.
Yeah.
Yeah,
Okay.
that's totally fine.
All right. Madam Clerk, are you clear on,
Yes.
okay. Is there any other change that we need to make? Seeing none, is there any reason not to approve the minutes of the previous meeting?
As amended, I agree.
Okay. Mr. Stewart?
I'm just cross-checking something on the front page. Yeah.
Okay, so we are all agreed, and the minutes of the meeting of July 17 are approved as changed pursuant to our discussion. All right, old business, is there any old business that anybody has? Seeing none. New business, potential appointments to vacancies on the board, question mark. One seat is vacant and an alternate has expired. Well, I hope you're still alive, but that is Mr.
Don't
Webb.
count on my memory for that.
Okay. That's Mr. Webb, who has chosen not to apply for reappointment. I should tell you that the mayor has reappointed me, and that is apparently working its way through the system. But we still are 2 seats short. If you are aware of anyone who is interested, I would like you to please let me know, or have that person contact me so that I can inform them of what the application process is. I'm very anxious to get a full complement of members and alternates here on the board. Any comment about these things from anyone? No?
No.
Not yet.
Not yet?
I don't have a biter yet.
Okay, all right, well, I hope you try.
I do, and I have.
Okay, all right. We then come to the next item on the agenda. That's the findings of fact and decisions, read BOA Appeal number 2014-1. You have seen Sally Cusco's proposed draft. Should we go around and talk about proposed changes? Mr. Stewart, I think yours was the easy one.
Yeah, and
I didn't bring a printout of that. Do you have one?
Well,
I have mine.
I can tell you, well, just give it a second here. Mr. Stewart, you had, I think you wanted to make a change, didn't you?
Paragraph 13.
Paragraph 13,
yeah, I think, was it in yours?
the last line.
Yeah,
Okay, and what was the change that you proposed?
it, as it reads now, it refers to,
Let's not make it,
oh,
no discussion here,
Okay.
simply.
I wanted to add along the boundary adjacent to the west residential use area.
Okay, and you
That
move
would-
that it be changed accordingly?
Yes, I move that.
Okay. Any second, Mr. Huxby?
Second.
Okay, all right. Now, for purposes of discussion, why is it that you want to make that change?
So that the 10-foot trees in height are all 10 foot on that boundary. They are not 10 foot on the rest of the boundaries. Some are 8, some are 10.
Okay.
And that clarifies that all of the trees along that boundary are in fact 10 foot.
Okay.
I think you should have mine.
Yeah. Which section
That's
was that?
paragraph 13. Give Mr. Hagsby a second to take a look at that.
Yeah, I don't have any, necessarily any objection other than the proposal that I made before.
We will come to that later.
Okay, that's fine.
Yes, Mr. Stewart?
I have a couple more that I would like to discuss too.
Let's first
Okay,
go through this one. Any further discussion regarding the proposed change to paragraph 13?
No.
It would add at the end of the paragraph, along the boundary adjacent to the west residential area. Any further discussion? Any objection? Seeing none, that is changed accordingly. Mrs. Stewart, any other changes?
okay, and this is just sort of cosmetic, but on number 3,
Paragraph 3 on
Yes.
page 2.
right. The Board of Adjustment finds that finding of fact number 3. I was
Yes.
wondering if that should be finding of fact number 4.
Yes, it should.
Okay, and then in that same sentence, resolution 2004-1, I think should be 2014.
You are
Yep.
correct. All right, Mr. Hagsby, do you see that?
I see it.
Okay, and Mr. Stewart, you're suggesting those changes by way of motion, and?
So moved.
correct. All right, and I will
Second.
say, okay, Mr. Hagsby seconded that. Any discussion? I think our worthy counsel here indicated that those are in fact typographical errors that need to be corrected.
There's one more.
Well,
Oh,
we go
okay.
through them one by one here. Any further discussion? Any objection?
Okay.
It's changed accordingly. Madam Clerk, are you with us on
Yes.
those changes? Okay, Mr. Stewart, another change?
On 6, the same thing, there would be just substitute 24, I move that we substitute 2014-1 for 2004-1, the type.
Second.
Moved and seconded to change that. Any further discussion? Any objection? So done, Madam Clerk? You see that? You see that as well? Okay. Any further changes, Mr. Stewart?
I've got one other thing that I've caught in here, and it probably is not an issue, but it could be. But the appellant filed apparently for an expansion to the substation, and the O'Neill, she's with the municipality, they briefed the P&Z that this was an upgrade, not an expansion. But then upgrade was used by the chair, by the CEO of MEA, or chief, the head manager.
What does the application say?
The application says expansion. But what I'm getting at is that the manager referred to it as an upgrade, agreeing with the way the municipality interpreted it. But an expansion could be an expansion of the existing lot, or it could be adding, but an upgrade could refer just to the original lot. It's the semantics. And I guess what I'm saying is, do we need to put something in here that talks in terms of the terms upgrade and expansion to or of the substation were used interchangeably during the P&Z and during our hearing to mean the same thing?
That is, first of all, are you making a motion that such a paragraph be inserted? Is that what you're doing?
Well, I'm wondering if this...
We need to discuss this, so, and the
Okay.
way you discuss things is that you have a motion on the floor.
Okay. I would make a motion that we add a clarifying sentence that indicates the terms upgrade and expansion to and of the substation were used interchangeably by all parties to the P&Z hearing and to the Board of Adjustment hearing.
Second.
Okay, it has been moved and seconded to add a sentence. Let's see where this best could be added, just so that we're all clear on this. How about making it a whereas clause, an additional whereas?
Okay. You're looking at putting it where?
At the beginning.
At the very beginning, there are several whereases. Do you see that
Yeah,
on page 1?
that would probably be the,
I think that would be the easiest way of handling it.
Okay. I think that would be a good fix. A good place to put it.
Let's ask our esteemed counsel here, what do you think about this?
Well, if it's a finding, then it should be in the findings. If the whereas is a kind of a preamble, so I think it depends on,
maybe it
If
would
you
be a
want it.
whereas just after the findings.
Well, the
But-
first is where her objection is, we need to be clear whether this is an additional finding that we made or whether this is simply a recital.
right,
Whereas clauses are simply recitals.
I think this is a recital on the interchangeable use of upgrade and expansion. The applicant filed for an expansion.
Are we into discussion yet or not?
Yes, we are.
Okay. Is, that, I tell you what, that's a hell of a thing to bring up at this point,
Well,
because.
I didn't catch it.
No, and frankly,
Neither one of us did.
I didn't catch it either, and But that could markedly change.
But wait a minute, all parties used the term interchangeably.
Did they?
Yes.
That much is clear, and as Mr. Stewart explained, even the CEO of MEA called it an upgrade.
Yes.
Did he?
But is that what the application was, for an upgrade, or was it for an expansion?
Expansion.
It was for an expansion.
So the application, the actual building permit, the P and Z application, when they went through the building department,
Yes,
that
yes.
was for an expansion,
Yes,
and then they called it an upgrade.
yes.
Well, then I would agree. You might as well put that in.
That was used interchangeably.
Okay, if it's used interchangeably by all parties,
Yes.
then I would have no objection to that.
I went through and documented where they used the term upgrade,
Okay.
and it's pretty consistent, but then every once in a while, somebody uses the term expansion. But when the manager, the head manager for MEA used that term as upgrade.
And was it, I'm trying to think back, was it actually an expanded site? Or was it
Well,
just?
it is an expanded
Well,
site because
yeah.
they bought an additional
They
lot
bought a
for
lot.
it, remember?
All right, yeah. Okay.
So, let's wordsmith this and come up with a proper wording of this whereas, both
I just
for
wanted
our
to-
councils and for the clerk's benefit here.
I thought if this is appealed, this could be an issue unless we,
I think
What I
that's a
find
very
here.
good point. So, would you repeat your motion, please, so that we are all clear? You're moving to add a whereas clause,
Whereas.
isn't that correct?
yes.
Okay.
Under findings,
No, the whereas clauses are
Under
ahead
whereas
of findings.
In the beginning.
Okay, and
in
it
that
should,
paragraph, in that paragraph.
Yes.
Okay, all right.
and it should actually be the very first whereas. It should be at the very beginning, I would
Well,
suggest.
yeah,
See-
because you're gonna use expansion, and you're going to use, everything that follows is an expansion or an upgrade, so it should be number one.
Yes.
First
So,
one.
let's see if we can come up with a proper wording of this, and I will help you if you will go ahead. Whereas the parties used
Use the
the
terms.
terms.
Whereas BOA found that the parties.
No, we are not
This
doing
is-
any findings,
yeah, this is a-
whereas
this is just a fact.
simply, it's just a recital, okay, so it's not a finding, simply a recital, whereas the parties used the terms, and what were the terms?
Upgrade
Upgrade,
and expansion.
upgrade, and expansion.
And I just noticed that.
Of an existing facility. Interchangeably.
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 In case 2013-159.
Throughout the proceedings, what should we say? Throughout
Would we say proceedings?
proceedings or the record?
The record.
The record.
We
The
record,
record,
right?
right?
The record, we don't have to.
Throughout the record
Good point.
on appeal and the BOA, Board of Adjustment, therefore treats or will treat the issue, no,
Terms.
the terms
Synonymously?
synonymously.
synonymously or interchangeably?
Synonymously.
Well, see, we've already said they've been used interchangeably.
Okay.
Yes.
So now this is,
All right.
For purposes of this appeal. Okay? Okay. Does that make sense? Okay? Let me read it to you again so that we are all on the same wavelength here. So the motion that Mr. Stewart made and that Mr. Hagsby seconded reads, there should be added as the first whereas clause, the following. Whereas the parties use the terms, quote, upgrade, unquote, and expansion, quote, unquote, of an existing facility interchangeably throughout the record on appeal, and the Board of Adjustment, the Board of Adjustment will therefore treat the terms synonymously for purposes of this appeal. Okay, are we clear on that? Any further discussion?
No.
Seeing none? No objection, it is so added. Okay, anything further, Mr. Stewart?
that's all I found.
Okay, Mr. Hagsby, any changes that you wish to propose? And I think in your case, I think if I understand you correctly, you have basically the same changes that you wish to make to 4 separate paragraphs. Isn't that right?
Yes.
Okay. And why don't you tell us what you wish to add, amend, delete, whatever?
I would,
You move.
I move to delete, let's see, just a second, let me make sure what I've got. Delete paragraph 10. Delete paragraph 10 and substitute
Well, just a second. You want to delete paragraphs 10, what
10.
other paragraphs?
10, 11, 12, and 13.
Okay, totally. And
Totally.
substitute therefore what?
Substitute for paragraph 10, Board of Adjustment finds MEA's light plan mitigation measures for the site were sufficient. Substitute for paragraph 11, Board of Adjustment finds MEA's noise plan mitigation measures for the site were sufficient. For paragraph 12, substitute in, Board of Adjustment finds MEA's drainage plan mitigation measures for the site were sufficient. Substitute for paragraph 13, Board of Adjustment finds MEA's landscaping mitigation measures for the site were sufficient.
Okay, for purposes of discussion, I will second that. Mr. Hagsby.
What I'm struggling with here is that we're picking parts and pieces out of the record and out of our own discussion. We're substituting our judgment here. Effectively, that's what we've done. And rather than to go through all of the words and try to cite the various paragraphs, parts and pieces in there, we ought to just find that these mitigation measures were in fact sufficient, leave it at that, so that these don't become, if we're all convinced, or it's probably evident that this may hit a higher court. I don't think it's reasonable to expect that you're gonna have a bunch of lawyers running around litigating small words in a paragraph that we may or may not have gotten 100% correct with the record. I'd rather just say, okay, they were sufficient, and leave it at that. Let's not let that be the argument.
Okay, I will defer my comments to later on. My thought is that we should ask our esteemed counsel here what she thinks. It would simplify, in my view, and shorten what is there right now. Do you see any problem with making those changes?
Well, they're conclusory statements versus the actual findings. the findings, if I recall correctly, Mr. Stewart put all of these findings that are in there on the record. And then the conclusion is that the mitigation is found in paragraph 15, which is the mitigation measures with respect to lighting, noise, drainage, and landscape were sufficient to adequately buffer the surrounding residential uses. And what supports that conclusion is those factual findings with respect to the low impact, the security lighting at the front entrance, the transformers. So I like it more specific. I tried to encourage Mr. Stewart to, when the discussion was taking place, to point to specifics, to give anyone who's looking information as to why you're making the conclusions. And these, if we substitute 10 through 13, those to me are all conclusions as opposed to specific facts that led to your conclusion, findings that led to the conclusion. So I like more specific, but you guys are the decision makers.
What do you think, Baron?
I would join our council's comments by simply saying the measures were sufficient as you are proposing to do. That's a conclusory statement, which is already contained in paragraph 15. If you look at paragraph 15, it talks about the measures that were sufficient. And it being a conclusory statement, it needs to refer to the specific facts that led to that conclusion. And paragraphs 10 through 13 are those paragraphs that led us, as they're worded right now, prior to your proposed amendment, those are the facts that we found that led to the conclusion in paragraph 15.
Do you think that would be, goes to appellate, if it's appealed, that's important, that be in there?
Well,
I
I can tell you, and I'm not going to make a decision here strictly based on what some judge might do or say once it is on appeal, but I must tell you, logically, the conclusion that is stated in paragraph 15 must be based on certain findings. Okay? And the findings are what is presently stated in 1 through 13.
9 through 13.
10 through 13.
10 through 13.
15's based on
Yes.
10 through 13.
Yes.
Okay.
And so for that reason, I'm not in favor of the motion. I would prefer that we leave it the way it is.
Okay, can I withdraw my motion?
No, we just simply
Okay.
vote on it.
Okay. All right.
All right, Mr. Stewart.
One of the things that, the way I look at it, is the information in 10 through 13 is the rationale for our finding.
That is a much better way of explaining it, and thank you very much for that comment.
Perfect. You're
And
hired.
somebody,
You're hired, you're fired.
All right.
somebody will look at it.
Any further discussion? Seeing none, please vote.
So what will the,
Of the motion to change paragraphs 10 through 13 by
motion to change,
deleting
okay.
and substituting, as he has stated.
How do you vote, Baron Kuchel?
Nope.
Robert Stewart?
nay?
John Haxby?
Nay.
Thank you. Any further changes, Mr. Haxby?
Pardon me?
Any further changes?
No.
All right. Then I have a few changes here that I would propose, and I move that as follows, that in the, which is now the third whereas clause on page 1, that presently reads, Matanuska Electric Association, in parenthesis MEA, appealed the decision of the Planning and Zoning Commission. I move that we add the term timely, because the appeal was timely filed, and I think it should reflect that.
Okay.
Next, on paragraph 18.
Do we want to just
I
vote
will,
on
no,
that?
I will do them all in one fell swoop. I
Okay.
think that's easier. And if there's any dispute or discussion, then I will separate them out.
Okay.
Look at paragraph 18, please. the second to the last line of paragraph 18, it presently reads, "It was a very small site and one of the smallest sites they have for a substation like this." I would like to change that to read, "Appellant has," so that it reads, "It was a very small site and one of the smallest sites appellant has for a substation like this." Okay? Next, on paragraph 22, last line, I would like to add the word "complete" between, so that the sentence there that starts "additionally" reads as follows: "Additionally, comma, the complete record relating to Shugacha, etc."
I might have a problem with that. We didn't have a record.
That's why he's putting that.
That's why
If
we're
it-
saying there's no complete, well, let me simply say that I would like to change that, and on the next page, I would like to add "was not part of the record on appeal" at the end of the first line, because the board can only consider the materials in the appeal packet, AMC 2130-080. It cannot determine the merits of appellant's argument, period.
I'm wondering if putting in complete suggests that there may have been any part of the record.
There was a part of the record.
Yeah, they had a piece of it in their appellant brief.
Oh, okay, I see what you're saying. Okay, all right,
Okay?
all right.
Then I have in paragraph 27, the last line, I would like to change to read, "He was given a longer time and completed his comments."
I think that's more accurate.
Okay? And then I think I have one additional change, and that is I'm adding a conclusion number 5 at the very last page that reads, "This is a final decision of the Board of Adjustment with respect to all issues involved in this case period. The parties have 30 days from the date of mailing or other distribution of this decision to file an appeal to the Superior Court." Somebody going to second my motion?
Second.
Okay. Let me address the conclusion number 5 first. It's a requirement of the ordinance that the parties be advised of the appeal process from here on out, and it is customary that this board adds that paragraph, and so I simply added that. Regarding the change to paragraph 22, I think it clarifies simply that there are 2 reasons why the appellant's argument was not accepted. The first is because each parcel of property is separate, and we are not changing any part of that language. Additionally, we did not have the complete record. We only had a partial record of what the appellant was trying to tell us, and we cannot consider materials outside the record, and because the complete record was not presented, we therefore cannot consider that argument. Regarding paragraph 18, I think that is simply a language change. And regarding the whereas clause change, the third whereas, I would like the record to reflect that, in fact, MEA filed a timely appeal so that there cannot be any issue over this. Mr. Stewart, I think you seconded my motion.
I did.
He seconded it.
Oh, Mr. Haxby, I'm sorry. Any discussion?
I think what you've added is, helps clarify the record, and I'm gonna vote for it.
Okay. Mr. Hagsby, any discussion?
No, I think it adequately summarizes.
Okay.
I'll vote for it as well.
Let us vote on the motion very quickly. The motion is to make the changes that have been indicated. Madam Clerk?
How do you vote, Mayor Gurke?
Yes?
Robert Stewart?
Aye.
John Haxby?
Yes.
Okay, with those changes then, the decision, the written decision, once it is prepared, Sally, will you prepare it or will the clerk do that? I think it would probably be better if you do that.
Normally, what I've
Yes.
done in the past is I would do it and just send it to you to sign.
And I will do just that.
Before you do that.
Okay.
I'd like to have a little discussion on paragraph 2, or 22, excuse me.
Okay?
And I don't know that I can make a motion yet. but
Okay.
I want to discuss.
All right.
I want to just read this, and then I want to talk about it. Adjustment, with respect to the appellant's first argument, the Board of Adjustment finds that a comparison of MEA's application for a conditional use permit to Chugach Electric's application is not appropriate because each parcel of property is unique, and the conditional use standards have different effects on different properties. Is it in fact, are they, when you're going in for conditional use, is it in fact, is there a standard or you're asking for a variance from standards?
Well,
I don't know that there's really a standard in a conditional use. There are property standards, there are development standards for different properties. But I think a conditional use walks right by all that stuff and says, okay, look, this can be a variance from a standard use, this can be, I don't know that there is such a thing as a standard, is there?
yes, and the
Yes.
ordinance specifically refers to the standards that must be met in order to qualify for conditional use permit. And when you look at the ordinance, and it is 2150-020, that states general standards for conditional use
Okay.
approval.
Okay, got it.
Okay?
All right, fair enough.
All right. Any further discussions, concerns about what we found?
Just one thing, and I'm just on the grammatics. In 22, did you say you were going to keep the word "and" in there towards the end between appeal and because?
Wait a minute. Where are you saying? I'm seeing the sentence, additionally, the complete record relating to Chugach Electric's conditional use application was not part of the record on appeal, and because the board can only rely on materials in the appeal packet, it cannot determine.
You meant to keep that in?
Yes.
Okay.
I
And
meant to.
only consider materials in.
Yes.
Right. As written.
Okay, so does that raise any
Yeah,
concern?
nope,
Okay.
that clarifies.
Anything further? All right. As stated, as soon as I have in my hot hands the findings and conclusions as changed here tonight, I will sign them.
Has there been a motion to approve the findings?
Just one second.
Okay.
Unless there is any further objection.
I think there might be one more minor grammatic on 14. The last part of the sentence was not supported by, in the record, by substantial evidence. I think that "by" should be just knocked out.
Deleted, thank you.
That's it.
All right. Any further changes? I will then entertain a motion that we adopt the findings and conclusions as stated and as amended.
So move.
Any discussion? Seeing none. Any objection? No objections? It is so. That motion passes unanimously, and as I said, I will sign it as soon as I have it in front of me. Okay, we're zipping right along here. Next meeting, we have scheduled an appeal in case 2014-3, and that is to be heard on October 8, 2014, between 5:30 and 10 o'clock. We have received today an appeal brief from the municipality, I believe. This is just to advise you, there will be more briefs coming. I can tell you that I signed an order giving an extension of time to the appellant, I believe, to file a brief a week later than originally scheduled. That was pursuant to an unopposed motion by both parties. So that the first brief that the appellant has to file is not due tomorrow, but instead on August the 8th.
It's actually the appellee.
The appellee, thank you very much for correcting me. Just so that you're advised, this was simply a ministerial act. There was no reason for us to get together about that, as the parties had agreed to it. Anything further regarding that next appeal? The three of us will again come together at that time.
The dinner will be served.
Yes. Okay, it will be. All right, anything else? Number 7, member comments. Anything we have to discuss here? Anything you wish to bring up? Okay.
Not on my part.
All right, audience participation, I think that simply refers to our esteemed counsel's comments that she may have, as nobody else really can say anything.
Not much of an audience. I have nothing.
Okay, and if there's nothing further, we stand adjourned.